If you're going to send a demand letter, what would the law firm do? So we unpack the facts, we set forth the various violations of the company documents and/or the statutory law, and then we set forth the claims we have in court. Then we like to shift and discuss a possible resolution. So we make clear that at this juncture, based upon everything that we've seen and what we see, that the breaches that we're aware of, we believe that we have claims for XYZ, which could result in extensive damages along with XYZ. And then we like to propose a potential resolution. We'll demand a full accounting of the books, records, profit and loss statements, bank accounts, tax returns, etc. of the company. Or in the alternative, if your client is willing to pay, let's say, a lump sum of $2.5 million, then we will agree to walk away from claims. And absent acquiescence to either the full auditing and accounting or the payment within X amount of days, we intend to pursue this action in court. The benefit of doing it like this is that you get to sort of create the narrative early on. The demand is still confidential, and it's a possibility of resolving the claim without having to spend a significant amount in litigation. So demand letters, the benefit once again is that they're more cost effective than litigation. The detriment is that it's not guaranteed to bring any result. Would it make sense to even send the demand letter, or does it make sense to go to court? Now we've moved on to the point that we need to file a complaint. When we file a complaint, what we do is, it's very similar in ways to the demand letter, but it's a lot more formalized. So we deal with the issue of jurisdiction, we deal with the issue of where the proper venue needs to be, and then we set forth all the facts in line item form as to what's taken place, when it took place, and then we bring us up to the present date about all the wrongdoing that's actually occurred. Any exhibits that are corroborating or support the factual assertions, we make sure to attach them to the complaint, unless for certain strategic reasons it doesn't make sense, or if there's a confidentiality issue we need to be mindful of, it may be redacted or submitted for in-camera review. We then set forth all the violations of the operating documents, and then we set forth our causes of action. It's the factual background, the violations of the operating documents, and then we set forth the causes of action. Breaches of fiduciary duties, unjust enrichment, breach of contract, usurpation of corporate opportunity, violations of the Lanham Act, if there's been any trademark infringement, violations of the U.S. copyright laws. We often make a demand for an accounting. And if we think that the company is on the brink of such chaos, we may want to suggest that a temporary receiver be appointed to oversee the actual conduct of the business to ensure that the business doesn't implode. Fight very hard to ensure that we're very professional, we're very tough, we're seeking the outcomes that our clients want. And at the same time, though, while we aggressively pursue an action, we're always keeping the line of communication open up on the side. If you have any other questions, you can email us. You can email me directly at ross@pitcofflawgroup.com. Shoot me a note on LinkedIn or Facebook, any social platform you're watching this on. You can send us an email, info@pitcofflawgroup.com or ross@pitcofflawgroup. And if you have a topic you're interested in hearing about, shoot us a note. We're really curious to hear what are your concerns or questions you would have, and we're happy to deep dive into something and kind of unpack it in a way that's valuable.